Stella Nyapendi Chombo is my name. I'm an advocate of the High Court. I currently serve as a member of the Tax Appeals Tribunal of Uganda. We have to do it efficiently, we have to be independent, we have to be fair, so that we're able to serve the mandate as it should be. But I should be quick to add that for tax disputes, the Tax Appeals Tribunal is a court of first instance. And this was laid out in the decision, Bravo Enterprises. This decision emphasized the fact that for every tax dispute, you start with the Tax Appeals Tribunal. Prior to that, we had instances where a taxpayer would choose either the High Court or the Tax Appeals Tribunal. But now, the principle is settled and all matters must start with the Tax Appeals Tribunal. And so we execute our mandate taking into account that. Thank you.
Also, maybe just a quick one, just a quick follow-up on that. What, in the commercial court, in the High Court, in the judiciary, cases are considered backlog when they are 2 years and above. We have many cases that are 10, 11 years. What's the backlog? What is that? How do you age cases? How do we know that this is now backlog in the Tax Appeals Tribunal? And what are your... Yeah.
Thank you. In the Tax Appeals Tribunal, what we consider backlog are cases that are below 9 Mr. Kawajwara. In terms of the experience and the qualification, the Tax Appeals Tribunal, and this is specified in the TAT Act, has a mix of specialities. We have lawyers, we have accountants, we also have finance experts. So there is expertise in accounting and law, meaning that not necessarily that everyone that sits on the who sits as a member of the tribunal is a lawyer. But 5 of us are lawyers, and the 4 have a mix of those of that experience. So that is who sits at the tribunal. I'll then go to the question of how it differs from a normal court. I mentioned earlier that it's a quasi-judicial court and specialized, meaning that it was purposely set up to deal with tax appeals that come from the Uganda Revenue Authority, but also that it's a court that should be easily accessible, it should be efficient, and it should be independent in the way it handles its duty and mandate. The other angle regarding how different it is from the conventional courts is that by design, being an administrative court, procedurally we operate with less formality and technicalities as possible. We do not apply the formalities that you find in the High Court, and what the current TAT is doing is to move away from the High Court kind of operation back to the administrative. We're taking up our mandate. It's one of those strategic.
I don't know if we can get you. I think I lost you a bit. I don't know if you could all hear. Maybe if you could hear, just give me a thumbs up, or if we had some sound issues. But if you're just joining us, welcome to the Judicial Service Conversations. The topic is breaking the backlog, fast-tracking fairness, and fueling growth. And Stella, you were just telling us about the Tax Appeals Tribunal. I hope we have you on back.
Okay, can you hear me? Okay, I'll then proceed. The Tax Appeals Tribunal is distinct from registered in the last financial year 24-25, was registered in the last financial year 24-25, was 11 months. Also, our case management rules are tailored to tax cases, being a court of first instance. So we are purely specialized, being a court of first instance. So we are purely specialized, and then we hear tax cases. So compared to court tribunal, There's a requirement for one to pay 30% of the tribunal. There's a requirement for one to pay 30% of the tax assessed, and this is provided for under Section 15 of the Tax Appeal Tribunal Act. It's also one of those principles that were laid out in two cases, UPMAC and Fuefling, and these cases emphasize the fact that 30% has to be paid mandatorily. However, there's some exception to cases that require legal interpretation. So for one to appear before the Tax Appeal Tribunal, you need not have a PC. Alfred, you can appear before us. You can actually have an accountant represent a client, and therefore that makes it purely distinct. So there is also appearance in person. And then also in terms of our procedure, we have dedicated mediators. I know that happens in the conventional courts, but we have dedicated mediators, and these we have a 60-day period to ensure that a matter is heard and mediated upon. At this point, this really helps us resolve disputes quite quickly. So there's mediation, but also, again, in terms of procedure, we have conferencing. It's one of the requirements that before we start a matter, before we get to hear the case, we'll require the parties to appear. And on the part of URA, we shall require the assessor and the objections officer to appear. And then on the part of the applicant, being the taxpayer, we shall require them to appear in person. When we have that conversation during conferencing, it's very informal to the extent that we do not, if you have representation from a lawyer, we'll want to hear from the applicant because they knew the story before the lawyer was given instructions. So that has made it quite simplified for us as a tribunal because we understand the gist of the matter, and oftentimes you see that it's a matter that can be resolved quite amicably because you get the understanding from both sides. You will ask the URA assessor to defend the assessment. They'll give us reasons. Oftentimes you'll find that the applicant has probably not provided the necessary documents, the documents to support their case, and then at that point we shall require them to avail the documents and then have the matter resolved faster than it ought to have been. Then the other critical aspect that I should mention is in tax matters and matters before the Tax Appeal Tribunal, the burden of proof shifts to the applicant. It is the applicant to prove that the tax assessed is excessive, or that the decision that was made ought not to have been made or may have been made differently. That's provided for under the TAT Act. Whereas in the courts, the burden of proof is on who alleges, the claimant. For TAT, it places a burden on the applicant to prove that the tax or the assessment is excessive. Thank you.
Thank you. Maybe just a simple question on the book. And appear and the areas of the court don't have certificates, and they have always been saying they are being burdened by the system, and I don't know they can practice tax before they are physically, and then they are those, because they love tax a long time, they never bother to get their first certificates because they now know what tax have to do. But does that mean that even just a lawyer now that you have these people who are finished, they are people and they are into the back post and they don't know that they're going to go to the back post? And they also still appear because they do not go to the
as long as the representative of the applicant is able to defend their position. Sorry about that. For as long as the representative of the applicant can present the case authoritatively and cite the relevant provisions and appreciate tax, we'll entertain them before the tax appeal tribunal. So yes, the lawyers that have just finished their law degrees can appear, but they must have expertise in tax, because if they do not, then they will be facing the URA assessors who will have probably much more experience, and then that will disadvantage their will disadvantage their case. So yes, they can appear. Thank you.
Thank you very much.
If you're just joining us, we're having the Judicial Service Conversations. We're discussing breaking the backlog, fast-tracking fairness, fueling growth. And we have Ms. Stella Nyapendi Chombo from a member of the Tax Appeals Tribunal. And we're going through all things tax. We just had, for example, that if you don't have a practicing certificate, you can go to the Tax Appeals Tribunal, but I think if there are clients who are listening, I would advise them I see my brother Ashraf Lubako is smiling and thinks that he can start appearing in the Tax Appeals Tribunal. I would completely advise against it. We're discussing all things tax. We've gone through some of the basic conversations. For those who don't know, one of the reasons why we are having a conversation about the Tax Appeals Tribunal is partly because they've issued a report, but also because just look at the difference that we've had. Tax Appeals Tribunal is talking about, I know our guests may not be happy with me saying it, but it's talking about 9 months backlog, 11 months average, while the judiciary, our friends, I can see some of our judicial officers online. My lords, I think we need to start reviewing this 2-year thing. If my lords, but I think I'll be making a prayer to my lords who I can see online, that my lords, really, people are saying they want to take backlog to 6 months, and my lords are very happy with 2 years, 10 years, 15 years. The appeal process in Uganda, in case you don't.
Stella Nyapendi Chombo. Now, I know she's talked to us about a little bit of the procedure when it comes to bringing a case. And just in case there's somebody who is listening in, probably a layman, but a taxpayer, I'd like.
If a taxpayer disagreed. Thank you, Joy. Where a taxpayer is aggrieved and disagrees with the URA assessment, there are statutory steps that they can take to ensure that the dispute is heard. The first is they will object to the commissioner in URA, and this objection must be lodged within a period of 45 days of the tax decision. So after receiving an assessment and you're dissatisfied, lodge your objection to the commissioner. The objection must be in a prescribed form. This you can find in the URA website, and it should have evidence, and it should include grounds of your objection. These must be supported. URA has 90 days to issue an objection decision to the taxpayer, or the taxpayer may elect to treat the objection as allowed if no decision is given by the URA. So after the lapse of the 90 days, if URA is silent, then the taxpayer can choose to elect, and that would mean that the tax is not due and probably not payable. So that is the first. And I must emphasize that the experience that we get at the tribunal is at the point of objection, you find that applicants, taxpayers, will not avail the supporting documents. And once that happens, it means that the case is already weak even from the onset. If you don't have documents, then URA has nothing to work on. But also on the part of URA, it is expected that even when they are disallowing, they should give valid reason. But what we see commonly is they will simply say no supporting documents, even where the taxpayer has evidence that they submitted the documents during that stage. Then after the taxpayer or URA has served the taxpayer with its objection decision after the 90-day period, then the taxpayer has an option of going for ADR. ADR is an internal administrative process within the Revenue Authority, and it's directed and it's based on regulations that were passed in 2021. These regulations permit the commissioner to offer taxpayers the opportunity to be heard, alternative dispute resolution. And during this conversation, again, they will look at the objection decision. But what I must add, that after receiving that objection decision, the taxpayer is expected to go for ADR within a period of 7 days. Now, one of the points of emphasis is that ADR within URA can as well concurrently run with filing the application in the tax appeals tribunal. So as the taxpayers apply for ADR, it is also correct for them to apply in the tax appeals tribunal to file. So the appeal to TAT also follows after the objection decision. We will not hear a dispute if we don't have an objection decision before us, because that is really the taxation decision on the part of URA. So the taxpayer at that point applies to the tax appeals tribunal within a period of 30 days, and we have forms that are used to file these applications. So when an appeal to the tribunal for review of the decision is made, it is filed in our offices. We have a registry at NIC, that's a central registry, but we also have presence in the regions. We have presence in Arua, we have presence in Bale, we have presence in Commissioner Legal Services, the other remains with the Commissioner General. Commissioner Legal Services, the other remains with the Commissioner General, and then the other copy is for the applicant. So precisely, those are that's the procedure that is followed, high level, for a taxpayer that is dissatisfied with an assessment. And when you come to URA, which can be done concurrently while they file, for ADR, they should do that within a period of 7 days. But because there's a 30-day window, then they can come to TAT, and then TAT will hear them. So yes, it can be concurrent.
Stella, thank you very much. I just have a follow-up question. You mentioned that the different regions do have a presence and that they can file their complaint, they can file in those different regions. Can they be heard, or the outcomes can come to TAT here? Is it just a filing reason?
Thank you. It's and ensuring that we take justice, tax justice to the people. Thank you.
Yeah, thank you very much. Thank you very much, Stella. Thank you very much, Stella. I think that answers my question. The follow-up question I have is with respect to the ADR. We've definitely experienced a similar mechanism of applying ADR in our court systems. And there's been a worry or questions about the values it has added to reducing case backlog. In your experience at TAT, and keeping in mind these timelines that you've mentioned, the 7 days, and I know there are very strict timelines when it comes to TAT, have you seen much value be added to the entire process and to dealing with disputes by implementing the ADR process altogether at TAT?
Thank you. ADR has added a lot of value to resolution of tax disputes. I must add that a number of our disputes are arithmetic in nature. 80% of the disputes that are before TAT are arithmetic in nature. Arithmetic meaning they are matters that can be reconciled. There are matters where you find that there was no meeting of minds between the parties before the dispute was filed before the tax appeals tribunal. So we found it very helpful. We have statistics that show that a number of the disputes were resolved through consent. So consent would mean that when the parties relook at the numbers and at the grounds of objection and exchange documents, then they know that there is no reason for them to appear before that. But also, the Tax Appeals Tribunal has oftentimes emphasized the fact that when you appear before the Tax Appeals Tribunal, there should be questions of legal interpretation. We have no business helping parties reconcile. We can only guide. And this we've achieved through what I earlier mentioned, the conferencing. When we have conferencing, parties are able to exchange documents, they're able to speak, they're able to understand each other and have a meeting of minds. So it has been very, very useful, but also because we have TAT-led mediation, where after, when the mediators engage the parties, then we send them back to URA and they have inter-party meetings, and ultimately we have a number of consents that are signed and executed, and cases are concluded. We also have many withdrawals where taxpayers get to understand that maybe my case is not as good as I thought. We have and so we have cases that are coming through that way. Thank you. So it's a very, very useful tool to resolve disputes.
Thank you, Stella. If you're just joining us, we are breaking the backlog. Fairness and fueling growth. Welcome to another edition of the Judicial Service Conversations, and we're having a fantastic conversation about the Tax Appeals Tribunal. I think on the 24th or 25th of July, the Tax Appeals Tribunal issued a performance report for the period ended 30th of June, for the period the 1 year ending on 30th of June 2025. And it was, I think, it's fair to say that that year has been, and maybe Stella you'll correct me, that year has been one of the best years of the Tax Appeals Tribunal performance since the Tax Appeals Tribunal was established. And I've seen in your report that it says that the Tax Appeals Tribunal unlocked 506 billion shillings in 1 year. So what does that mean, unlocking? Does that mean that URA was able to get 506 billion? Or does that mean, where was it locked? You know, there are people now, there are people now who walk around talking about unchaining things. So we want to know, where was it chained? And how was the Tax Appeals Tribunal able to unchain 506 billion? Now, if you think about 506 billion, you will realize it's a lot of money. If you just, wherever you are, just stop and think about 506 billion. You haven't thought about that money at all. At least for the people I'm seeing on the space, and those who are in the room, I know, for example, that in the conversations he has had this week, my friend and brother Nicholas Opio, who is on, has not talked about 506 billion, I am sure. Wherever he is, he has not talked about 500. He has talked about maybe 5 something or 6 something, but 506. So, what do you mean you unlocked it? Where was it locked? How was it locked? And congratulations also as a tribunal on, I think, what has been your most successful year yet. I think is clear proof of people who are mission based.
Thank you. Before I answer the question, I wanted to just make some exception. Yes, 506 billion is historic, but the exception I want to make was the Heritage Oil and Gas case 2011. This case unlocked trillions that got into 1.2 trillion shillings at the time, that got into the government coffers. And
yes, that was what we know as the handshake case.
Yes, so that year there was it was quite a milestone for the country. But as, besides that, the 506 billion for the year 2024-25 is historic, in the sense that the year before we had the tribunal had unlocked 219 billion shillings. And so the 506 billion is a representation of an increment of 144% from the previous financial year. And in the previous 2020. So this reflects the growing confidence that the public has in the Tax Appeals Tribunal as an independent forum for resolving tax disputes. So this money was locked in the courts. It was in the Tax Appeals Tribunal. And so unlocking it means it is now out there.
Statistics, you've heard of the more people filing and more people coming out. But what I've really liked is the philosophy, unlocking money, saying that whether the money goes back in the pockets of government or the pockets of the taxpayer, that money has returned into the economy, and that money is being unlocked. That once it's locked up, once there's litigation, money is locked up. Once the litigation is over, money has been unlocked. But Alfred, I can see, has a burning question, maybe before we go to Mercy.
Yes, thank you, Mr. Ession and Stella. You see, when the report was released, I have a tax lawyer, I think he's on call every year, and he reached out to me and was like, you see, for us, what tax lawyers are doing, we are contributing to unlocking money into the economy. Well, for you who practice from the normal courts and the so-called, you are again just locking money in courts. So I think my question regarding that, I need to understand how the tax lawyers contribute to unlocking that money, because they are there bragging that for them they are contributing to unlocking money, while for us who practice in ordinary courts are contributing to just locking money in the courts. And I want to understand their contribution so that this guy maybe stops bragging with that. Thank you.
Mm-hmm. Thank you, Alfred. I mentioned earlier that you need not be... Thank you, Alfred. I mentioned earlier that you need not be a lawyer to appear before TAT, but yet it is true that lawyers have been they've been contributors to the success, to the extent that we have a number of lawyers that come and represent their clients. And when I speak to statistics, for these disputes that resolved, 266, URA won 56% of the disputes that were litigated, while taxpayers took 44% of the disputes. And the gap between URA and taxpayers is quite narrow, it's 12%, so it means that those lawyers are doing a good job and they are taking home some good money. But we also have categorization of these disputes. We have high value disputes, and these are disputes that are above 5 billion shillings, and these represent quite a percentage in terms of our statistics. And these are usually disputes that are questions of law, but also they are also very complex cases. You have transfer pricing, you'll have banking, you'll have telecom. So these are the ones that are high value, and the lawyers have been very active in representing their clients, and they've played a part in filing their submissions on time, in filing the relevant documents on time, and therefore facilitating the delivery of our rulings, but also concluding the cases with time. They've also been quite expeditious in pursuing the matters. Even when it's consent, you see them quite active in ensuring that they engage with URA to ensure that their clients are well represented. So the lawyers have done a good job, and we continue to urge them to come and do their best to ensure that they support the disposal of tax disputes. And it's not just disposal, but we're calling it rapid disposal, quick disposal, because efficiencies must happen for us to be able to unlock the revenue, because there's been a surge in applications. We are seeing a trend where we have 34 applications that are filed on a monthly basis. And if I speak to just August and July, in July we had 42 new applications. That meant that it was a result of the assessments that came through in the month of June, when URA was reaching to achieve its target. So because of the assessments, then you have an increase in applications that they go to 42. We don't even know what is in ADR, but that is the level of grievances that came through. Then in the month of July, we had around 34, 35 new applications. So if you're having almost 80 applications in 2 months, that speaks to the fact that we can only see an increase in these applications. And the increase is also a result of the fact that there is increased economic activity in our country, and therefore you'll see more interest in presenting disputes before the URA, but also coming to the tax appeals tribunal where taxpayers are aggrieved. Then there is also increased staffing. By the way, when there is increased staffing in URA, it means there are more assessors. So we saw an increase in staffing in the Revenue Authority. So meaning that there is also an increase in assessments. The more assessments, the more likely that taxpayers might be dissatisfied, and therefore you find the disputes coming through to the tax appeals tribunal. So there's a surge in these applications, and that calls for more proactiveness in concluding the cases to ensure that the disputes are resolved and the money is released back into the economy. Thank you.
Okay, thank you very much. If you're just joining us, we are breaking the backlog and fast-tracking fairness and fueling growth. Interesting statistics we've just had there. I think there are some things that can immediately be deduced. Most of the cases which you are won, it is fair to say they were not represented by lawyers. I think the ones where the 40% reflect qualified lawyers here, so I think members of the public who are listening, look for the members of the lawyers on the group, and remember, if you have a problem at the tax appeals tribunal, it's better to be represented than not. The second thing is that the increase in the assessments can also be because maybe we need to improve the mathematics at the Revenue Authority, since some of these disputes are arithmetic. Maybe board bus is failing. But Mercy, what do you have to say?
As for 2 years, for instance, and TAT is defining backlog as 9 months. Why is TAT placing such a high standard compared to the commercial court? So for me the question is, why is there a difference in standard? Because we've already had a number of discussions in this space about the amount of money that's locked in at commercial court, and we're seeing TAT fighting to help with this goal of the tenfold. I think you've really mentioned it a number of times. I'm going to go and read it, but I just want to understand from you why you think the 9-month goal, the 9-month definition for case backlog was important for TAT.
Maybe if I could just add onto that question, I don't know if it is wrong at ease or things fall apart. I don't remember, where somebody went to demand money from someone and he told him, he drew lines and then straight lines and then drew lines across them and said, you see all these boxes here? And he told him that this represents the people who I owe money. For you, you're still at the bottom. I first have to pay all of these people before I reach you. Is it not really how backlog works? So the question is, how are you able to pay this guy early? Why is there no unified standard? I think, Mercy, if I got your question.
Thank you, Mercy, and thank you, Ellison, for the question. In terms of standard, TAT defines its own standard, and this is because I mentioned that we found a case disposal rate and backlog that was defined at 13 months. It was 13 months before. And so at this point, the TAT is averagely 11 months, and we are looking to 9 months. So that is still way below the 2 years. But my thinking is that for the judiciary has a mix of cases. You have civil, you have criminal, you have family, but that is a specialized court. Specialized to the extent that we hear tax matters, but these are also commercial in nature. A commercial dispute means that you have money that is tied up. If you have over 5 billion cases representing 75% of the disputes in the tax appeals tribunal, then that means that we have to work quickly. There has to be increased efficiency. There has to be rapid disposal, because the government needs the money, but the taxpayer needs the money. Actually, even talking about the small taxpayers, those, we have about 223 disputes that are for small taxpayers, and those are disputes below 200 million shillings. Now, that is capital for somebody down there in Chikubo. That's capital for a small and medium taxpayer, and those are the ones that we have to handhold to ensure that we resolve the disputes. Even for a law firm, So those small businesses are businesses for tomorrow, and so it's important that we resolve the dispute so that the money is no longer with the tax appeals tribunal. And I've always said that a dispute before the tax appeals tribunal is like a hot potato. You got to just release it as fast as you can, and so because it burns, it will burn you. So that is what guides us in ensuring that we add speed. In fact, one of the reforms that we made at the tax appeals tribunal is prior to 2024, we only had one courtroom that was hearing these disputes, and we were hearing 8 disputes a day. And when we operationalized the second courtroom, that meant that we now can hear double the number of cases a day. So that means that the disposal rate has to increase. But also, we are guided by the fact that there's a surge in applications, as I mentioned earlier. So if an application is filed every day, you need to act quickly so that you don't have the backlog. So we have to ensure that we expedite matters so that we are able to deal with the cases, but also not to hold cases any longer than we should. Thank you.
Thank you. Thank you very much for that. I think it's very encouraging to see that there's increased trust in the independence of TATs, and especially that you're handling them like hot potatoes. You don't want to hold them for long. And I think this is a build-up, more like a 2-in-1 of what you've just answered right now. I know that you mentioned earlier and used the term arithmetic as the nature of the cases or the disputes that you're handling. And some, I think you've given a number, which I can't get right now, but you've said there's been like lots of reconciliations. So I'm wondering if most of these disputes are arithmetic in nature and they could be reconciled given the percentage that you've given us. We're wondering why are they not being resolved at the URA level? Why do they have to first come to TAT? Or what do you think is causing that? And then also we see that when it comes to the high value cases, just 41 of them make up about 3/4 of the money in dispute. So wondering why these cases are taking long. If you could help address that. Thank you.
billion Uganda shillings, and then the others 35 billion. So you can see that we had a higher portion of the monies that were unlocked through litigation, but yet there was 106 billion shillings, 156 billion shillings, representing 31%, that came through the consents. And so that takes me to the question of why the high-value disputes take longer than necessary. I don't think it's longer than necessary, given that our average disposal is 11 months. However, I'll be quick to add that a number of those disputes are on very technical areas of tax. So we'll have transfer pricing. A transfer pricing audit in the URL will take between 3 to 5 years. So you can imagine 3 to 5 years of the assessor and the taxpayer engaging and auditing and exchanging documents. And then you present a high-value dispute before the tax appeals tribunal. So we'll have, it concerns multinationals. You'll have telecoms, you'll have banking, you'll have, a number of emerging areas. And I'll also be quick to add that, you see, tax is ever-changing. We have international tax. And because it's ever-changing, you can see from the Ugandan experience, we change the tax laws on an annual basis. And so you have to be very careful in hearing the matter, in writing the ruling, in analyzing the evidence, looking at the documents. So they take longer, but also we also have quite a number that are resolved through consents. The parties will speak and engage and resolve the matter at that point. So high value takes longer than expected because of the fact that they are more complex. They are more complex than the small and medium tax issues that may be rental, maybe withholding tax, or any related area. So I hope that answers you. Thank you.
There was the other bit of why some of the cases, some of them can be, most of them, I think even the percentages would be handled through reconciliation. Coming to the bit of the arithmetic disputes and why it is that they come to you and not at URA. I don't know if you had addressed that. It was a two-in-one.
Thank you. I hadn't addressed that, but for the arithmetic and what we call the reconciliation cases, usually the common areas that we find parties not agreeing to is one, on interpretation, but secondly, on the aspect of exchange of documents at the point of objection. So during objections, the taxpayer will submit documents, and then the URA officer has 90 days within which to reach a decision and take a decision. And so we think that oftentimes maybe the taxpayers, I mean the URA officers, may not have ample time to look at the documents, especially if the documents are so many, and also if the case is complex. Then also arithmetic, to the extent that there are issues, expenses, where the invoices, the taxpayer sometimes will not avail those documents. And because the burden of proof is on the taxpayer to prove that the tax is excessive, that the decision was made, but yet the tax is excessive, you only can do it by way of documentation. So we have very poor financial management within the general public. So where people don't keep audited books of accounts, where people don't have invoices, then the revenue officer, the assessing officers, has nothing to work with. But yet there are also instances where they will have presented those documents. But because the time was not enough, we see those documents come through during the mediation, during the conferencing, and when they have that exchange of documents, then they get to agree on the arithmetic. They reconcile. We send them back to retrieve the documents and exchange and understand each other and reconsider, and that's how you have them agree and ultimately reach a consent. So yes, there are a number of those issues that are reconciliation. And we've emphasized the fact that we can only direct you on which documents to exchange. If you're giving financials, just avail them to the officer, and then we give timelines for the officers to actually do what they have to do. And therefore, that is where we find ourselves. But also, As the Revenue Administration, we've seen instances where they have staff transferred. So when a staff is transferred, it's arithmetic, but because the officer that was handling the case left and did not hand over, or is transferred to another station, or is on leave, then again, you find cases of the sort. But also, we've made an analysis for the small taxpayers, small and medium, those below 200 million. The assessing officers are maybe not as experienced. The ones in the large taxpayers' office are more experienced and grounded, and therefore those are able to resolve some of the issues. But then for the arithmetic, you find that the small taxpayers, most of those cases will be cases that just require reconciliation because the assessing officer at the time did not apply as much attention that they ought to have, and therefore they find themselves coming before TAT. So being in the taxpayer shoes, it's because the timelines also dictate that you only have 30 days. So even as you keep engaging, you see that time is running. And so after getting the decision, the best alternatives you have is either ADR or you run to TAT. You first file and then you probably exchange documents later, because now you're looking for a remedy that will save you from paying, or maybe ensure that you're paying the correct tax. And so coming to the tribunal, for me, I recall when I was in tax administration, we always said that everyone should pay a little so that no one pays more. And so when you come to the tribunal, it's incumbent upon us to ensure that taxpayers, if they have to pay, they pay the correct tax. And that's why we put it to the URA assessing officers, objections officers, to defend the assessments, especially where taxpayers have cooperated and provided all the relevant documents. But in the same vein, we will advise the taxpayers that while they file an application, it's their case. So they have to cooperate, they have to be in position to avail the relevant documentation, relevant financials, to ensure that the case is resolved as it ought to. Thank you.
Thank you. If you are just joining us today, we are talking more numbers and some little. If you're just joining us, today we are talking more numbers and some little English. Sorry, if you're just joining us, today we are talking more numbers and some little English. So when you're submitting and you submitted that the consents represent 160 billion, which as a result of buyer consents, and because of that, you unlock 106 billion. I would just take, I think, also lawyers who for the commercial court where there is too much money which is still locked. You also embrace more judgment so that you can also unlock some more money. At least I have a lawyer who says for him is a man of consent, that Christians don't bring food on the table. So you try to consent as soon as possible so that he gets money on the table, because litigating until he gets a precedent won't bring any food on the table. But this brings me to the next question. You see from your submission is on the number of applications filed before the tribunal per month. You entered on 34 on a monthly basis, some 10 applications. So it just shows that at the end of the year, more cases are filed in the tribunal than those which are disposed of. So it keeps me wondering how big a challenge is this, and what can we do about it, this challenge? How can it be addressed? Thank you.
Thank you, Alfred. The challenge of increased applications, I mentioned earlier that there's increased economic activity, and of course the lawyers are more litigious, people are more aware, but also people are hungry for tax justice. It's only fair that people pay, an applicant pays taxes that they ought to pay, but also give Caesar what belongs to Caesar in the same vein. Now, we are receiving a surge in new applications, and mentioned earlier that we received 34 applications averagely for just this financial year that began. We so far received close to 80 applications in just 2 months, and this gap again is is a benefit of saving time. But also for the high value disputes, we are looking to have specialized sessions to handle these disputes, and it will be dedicated 2 weeks where we set the cases for hearing, and then through to the filing, we will get the submissions filed after the 2 weeks dedicated period, and then we churn out the rulings. So we are looking to have that dedicated to high value disputes, as we have the single member panels for the smaller disputes. Actually, for the smaller disputes, sometime in May, we had some dedicated 2 weeks where we had just those ones, and we saw quite a result in doing that. So we will keep fast tracking for the arithmetic cases. We will continue to encourage the appearance in person for both the taxpayer, the applicant in this case, but also for the assessing officers and the objections officers. So we require the URA officer to come and explain the gist of the application, and that also has a real impact of ensuring that the cases are heard and concluded well within time. But also we have also constant engagements with both the taxpayer and the tax administrators. Those engagements are able to iron out areas where we can improve and have a meeting of minds to see how we can expedite the processes of resolving disputes. We also learn from regional experiences. We've had interactions with the Kenyan tax appeals tribunal, and from the experience, one of the things that they actually do is, in terms of membership, they have more than 15 but less than 20 members of the tax appeals tribunal. Of course, they have more applications, but they also get to employ expert panelists, mission panelists. So they are able to employ that for a time period and then work to resolve disputes quite efficiently. So those are some of the things that can work practically in our jurisdiction. Thank you.
Thank you. I think those are very practical. But then talking of mediation, because it's also practical and has a big impact in solving cases faster. Who can qualify to mediate cases at the tribunal? Like, because I know people who are mediators, even they may be there and I qualify to mediate cases at the tribunal. Who qualify? Thank you.
The nature of cases that we have before the tribunal are tax related. However, they span across different areas. You will have infrastructure related issues. You will have policy. You will have transfer pricing. You will have international tax. You will have business. You will have people who you will have economics. You will have a mix of things. So whoever is qualified to be as a mediator, you will have law, you will have accounting. So it's one of those broad areas of practice. So as long as you have that qualification, then you qualify as a mediator, similar to what we have in the High Court. And again, whereas we have lawyers, but there are those who are not lawyers because of the nature of disputes. It cuts across law. And then you also have to understand the nature of business in this country. Thank you.
Thank you very much, Stella. I think I wanted to write down all the resolutions you gave so that we can mirror them in other courts. But it's very interesting and very practical. I really appreciate you providing us that detail. I really appreciate you providing us that detail. You did answer my next question, which is about automation and digitalization of TAT, because I think we've appreciated what ICMIS has done for our court systems, at least in Kampala and other places it has been rolled out into, and I think it would add a lot of value to how cases are being determined at TAT. What I want to do right now maybe is a little bit of an icebreaker. Today I went to court to attend a matter, and we arrived and the judicial officer wasn't present, and the matter was for 9, and I think at about 11 were told that the matter was being adjourned to another date. We're dealing with an NTC, which means that we've been waiting and we need to dispose of this property to help the bank recoup its money. It's a notice to show cause why execution should not proceed. Now, this is a date we got in April by the judicial officer themselves. This is a scenario that many lawyers will tell you they've experienced in a number of courts. But in my short practice while at TAT, I did not have those experiences. At least when there was any level of adjournment by any of the parties would appear online, something would happen. How have you been able to maintain that standard at TAT? And how can other judicial bodies or panels or whatever borrow the principles you've applied at TAT to ensure that you actually have a hearing when you say you're going to have a hearing, and that you'll have, adjournments as minimal as possible, and they're not because of the panelists not being present, for instance?
Thank you, Mercy. TAT has managed to do that only because we are very emphatic on the critical and noble role that we have to play in resolving the tax disputes. I emphasized earlier that we are alive to the fact that the tax disputes are commercial disputes, and we are reminded of that for every dispute that we handle, big or small. And we have Zoom sessions where we find that a panel member is held up, especially for mentions usually. You can get on Zoom and ensure that there are no adjournments, and a mention is really part of the procedure that we follow for a case. That when a case is before TAT, we have conferencing, we have mentions, but for mentions usually there will be cases where we want to hear the status from the parties, and that usually follows for cases where there's been commendable progress in reaching a position for the number of the disputes that come through. So when it's one of those cases that will have 30 minutes appearance, you can have a member appear on Zoom just to ensure that we are fully constituted. And then also, exceptionally, we also ensure that we emphasize to the TAT users that when we schedule a date for you to appear, you must appear. Even acknowledging the fact that TAT operates with as little technicality and formality, but will not be kind where an applicant does not appear to defend or make their own case that they filed. That would mean that they're not interested. And then for URA not to appear where they know they have to defend their assessment, we will not be constrained to give costs. We will award costs to the party that is present if they've been inconvenienced by the other, or even where the applicant doesn't appear, we'll give one chance, and then the next time we'll dismiss the matter, because we are not in the business of having backlog. And if a taxpayer and applicant is not interested in pursuing their case, then why should we have it before the tax appeals tribunal? So we've been emphatic regarding our standards, including timelines for filing the relevant documents, the joint trial bundles, the witness statements. It's important that sorry about that. So where it's sorry about that, the interruption. So TAT has often emphasized the standards. We emphasize the timelines to conclude disputes, and when the users appear before us, we'll emphasize the fact that they have to cooperate. They have to cooperate in filing the joint trial bundle. They have to file their witness statements on time, whatever it is that is required to facilitate the quick resolution of a dispute, we employ. So this we do because we are cognizant of the mandate that we hold. It's a noble mandate. It's a mandate that supports the economic transformation of this country. It's a mandate that has the potential of encouraging investor confidence and attracting foreign direct investment, and also a mandate that is able to guide tax jurisprudence. So we are quick to ensure that we stick to our mandate, but also rapidly resolve these disputes. So it's basically been a point of ensuring that we have as many more adjournments as possible. We only adjourn where necessary, and that adjournment will rarely be because of the absence of panel members. So we're just committed to the cause. And in doing our work, we also ensure that we act professionally, we act and we keep time. Most of our sessions, if you've appeared before that, if it is 9, it has to be 9. If it is 11, it has to be 11. And that is what guides our performance. Thank you.
Thank you. Thank you very much. If you're just joining us, we are on breaking the backlog, fast track fairness, and fueling growth. You talk about Zoom hearings. I remember someone came here, but we've also all seen it in practice, where you ask someone a question on you ask someone a question on Zoom in a cross-examination, and the question becomes too tough, and the guy starts saying hello, hello, and then before you know it, he disconnects the thing. When he comes back on, and he just makes sure that it is difficult. It's good to hear that people who are applicants and the tax body who are fighting in tax disputes do not find technology as a convenient tool to dodge questions. Many of us in practice have seen that every time you ask someone a question on Zoom, where were you? Can you read paragraph 3? It says, I can't hear. So it's good. Technology is working well for you in that. But I think the bigger question which many people have is is that a good experience for people, in the sense that because we used to leave all these tax disputes to the High Court. Has the establishment of the specialized courts helped Uganda? And do you think we should see more specialized courts, maybe family, environment, like specialized courts of the tribunals? So the question is really whether, overall, if we can limit it to that, overall, what would you, as a person who has practiced a lot in tax, who also is a private lawyer right now, advising in many areas, but who also sits as a member of the Tax Appeals Tribunal, would you, I'm sure you would agree that the TAT overall has been a value add, but if you're to just tell us if you just to give us a bird's eye view on what you believe is what TAT has really added to Uganda. And please, if you're joining, thank you so much. We are having a special conversation here, breaking the backlog, fast-tracking fairness and fueling growth, with our guest Stella.
Thank you, Ellison. Just before I get to answer the question, I wanted to speak to the Zoom sessions and the TAT experience. So for TAT, when it's a hearing or a conferencing, we require physical presence. You must be present physically. We will not have a witness being cross-examined on Zoom. So at that point we require, and when we are setting the matter for hearing, we'll emphasize the fact that parties and their witnesses have to be physically present. The exception will only come where we have dimensions, where we are looking at updates, a mediation report and all that. But where there is cross-examination and we're getting into the crux of the case, will require physical presence, and that we emphasize. We've sent guidelines. We've emphasized to our users every time we have the stakeholder engagements, and we're achieving that to a great extent. The lawyers and the applicants and the URA respondent have been very compliant in that regard. And then the question of whether we've seen benefit in specialization. Yes, I must say there's a lot of benefit having TAT as a specialized court, having TAT as a court of first instance from the decision of Rabo in 2017. We saw taxpayers run to TAT. Now, specialization, because when institutions like TAT are specialized, then that means there is increased efficiency in handling the complex cases, because in there, from among the 8 members, we have people who have a mix of expertise. We have people who have expertise in infrastructure, we have people who have expertise in accounting, we have people who have expertise in telecom, and we continue to even improve ourselves. So there's a lot of benefit in having a specialized court. But also, if you look at the consistency, there's improved consistency in the ruling through. If TAT has pronounced itself in a matter, then we're able to cite that matter for the subsequent cases if they are filed before the TAT on all fours. Then we are able to pronounce ourselves. So you see consistency for the tax advisors. They will use that to even advise their clients, and therefore there is certainty that comes through the advisors. Then there is also better public confidence in the system. If you have tailored and visible justice delivery that is evident from the performance, that is evident from the way you conduct business, that is evidenced through the simplification of processes, then you're able to build that confidence, and then you'll have a demand for your services that are coming through. So the tribunal or specialized courts are usually quite accessible, informal, accessible to the general public. When when taxpayers appear before the TAT, will, for example, not require them to stand like you do in your conventional courts. We'll make them feel comfortable, informal. Just let's hear you speak in a language you understand. Where they cannot speak English, will benefit from the interpretation services. So there's a lot of benefit, accessible justice, and generally you see that we're able to deal with the backlog because of these interventions. So specialized courts are quite critical to this country. It gives speed, it gives predictability, it gives certainty, and then there is basically expert decision making in the decisions that come through a specialized court. Because if you look at technical areas like law, look at specialized areas like accounting, banking, telecom, now that kind of expertise is seen from the decisions that come through. Thank you.
Thank you, Stella. I think from the discussion, which has been ongoing since 7 p.m., so for those who have just joined us, we have been having since 7 p.m., and if you have questions, like some of you have already said, you can send them in our inbox or chat comment section to address them, or in the future we are going to because of members to speak and we give an opportunity to ask a question. But from what I've seen from discussion, I realized that whereas the TAT has been really unlocking money, it also experiences backlog. And the lesson here has been the judges since January, and the message is sent. No one now, everyone understands the judges. I appreciate it. You have been a good preacher for that. So I know today you came to ask very many questions to Stella, but for this one I want to ask it to him. Just stand the time. As he came to ask questions, you are listening, you need to answer this true or false. from my end. So, Edison, from your briefing on mission-based judges, first question is, what do you think about the idea of mission-based judges or panelists being deployed to attack the backlog at that? Because we have seen it also has some backlog, and then that there's too much money involved that we want to address it faster. And then, in addition to that, there's a second question of, from your experience as a young lawyer who has practiced for 2 decades, what lessons can the judiciary learn from that experience in unlocking economic growth and money value because by using quicker resolution of disputes the way it does? Thank you.
Thank you, Alfred. Thank you, Alfred. I think, first of all, if we are looking at when we speak of mission-based panelists or mission-based judges, we don't say it as a criticism to the people who currently serve in the judiciary. So if I'll take, for example, your first question, I think already Stella here is a mission-based panelist because apart from giving her time to the Tax Appeals Tribunal, she's also a lawyer in private practice, actually still going to her office and advising her clients. At the same time, resolving disputes, releasing 506 billion shillings into the economy. Are there people who can be more temporary than her in the tribunal and help? Yes. Overall, though, I think the numbers don't lie. In 1 year, 506 billion shillings released. I need to check now what the budget of the Ministry of Health is. But I think that's a substantial amount of money within the budget of the Ministry of Health. Within the judiciary's own budget. Within, just the amount of money released. The fact that trillions of shillings, people are saying that I need tax justice and they are and it's worth more than 1 trillion shillings right now being adjudicated in the tribunal. The fact that you have those numbers, 34 cases a day, means that at least every day in a month there is more than one taxpayer unhappy with his tax assessment and confident enough to take it to the tribunal. I think that is because you have 20 working days in a month, if you take off the weekends. So if you have 34 cases, then you have certainly more than, in some days at one, but certainly more than one person. Is it properly staffed? We have seen from the tribunal what extra hearing day does, what more mediators do, what more hands on deck, properly led, who understand the mission do. So, to the courts of judicature, a judge, I traveled around this country and I can tell you that there are judges in Uganda who are sitting on 1,000 cases. That's their docket. Today, the family division of the High Court today had a conference to plan for an influx of cases that had been filed for administration causes, and they're going into a session that was opened by the current acting principal judge today. Thousands of people are waiting for their school fees because it is held up by dispute. So when you look at the reality is that what we have seen from TAT and the other tribunals, there's the Electricity Disputes Tribunal, there's the Tax Appeals Tribunal, there's the Industrial Court, we may have its own challenges, but it's doing a great job. What we've seen is that backlog cannot be the destiny of cases. We cannot proudly say that we have backlog. It is not our destiny, but it is our enemy. And we must think of backlog as a war, and we must actually go to tackle it. Because I'll tell you who is hit hardest by backlog. The poorest. People who actually can't afford to go to court every day and argue for their cases are hit really hard by backlog. I think it was in this court, it was in these conversations where I think it was, I'll remember who it was. I think it was Mr. Bila who told us of a woman who used to travel maybe more than 100 kilometers every time for her case. And the case never came up with witnesses from the whole village. Backlog is how the system is broken, and we need to fix it. Article 142.2 of the Constitution is clear. It provides in no uncertain terms that you can deploy lawyers to help resolve disputes when judges are overwhelmed. And that article can help liberty, it can help revenue, it can help a lot. If people who are working full-time elsewhere are sitting as panelists on the Tax Appeals Tribunal and are releasing 506 billion shillings into the economy in 1 year, what is wrong with thinking of a few such people in the land division, in the criminal division, in the family division? The lesson is written in figures, but the meaning of that lesson is moral. Justice delayed is justice denied, and that delay is our enemy. When people are deployed on a mission, backlog can fall, trust can rise, prosperity can follow. You can break the backlog, you can fast-track fairness, and you can fuel growth. And so, that is a very long-winded answer to you, Alfred. And I hope I've answered every part of your question. The point is, TAT is a shining example. It is a city on a hill. It is a lighthouse. And somebody once said that you cannot light a candle and hide it under your bed. And he went on to say, let your light so shine before men that they may see your good works. So, and appoint mission-based judges. But I think Stella wants to agree with me. I can see she has to add. I think she should add in agreement with me.
That TAT is a city on a hill, that it's a lighthouse, and it's indeed shining because we take our mission quite seriously, but also maybe to that extent because the TAT members are members that are actually employed on contractual basis. So maybe that answers your question in part, but yet still able to perform the role that they should do. They should. But I also mentioned that, like the example that we have in Kenya, their mission, their mission-based panelists for the Tax Appeals Tribunal, they're able to employ experts just so that they reduce the disputes. But I'm also alive to the fact that in South Africa, they have temporary judges. Although this is drawn from their constitution, they have an article that actually speaks to that. Their application of that only applies where a judge is absent or maybe there's a vacancy. So maybe it can work for as long as it supports the enemy of the backlog. Thank you.
Thank you, Stella. Maybe this one you didn't answer my second bit of the question. Well, at least you left that there's light in the chart, but there's some kind of darkness in the judiciary. monitored so that we can also have that rate.
Okay. Now, first of all, I'm very honored because every time we have these conversations, I see a number of judges of the High Court of Uganda. And my lords, you are most welcome. I have today, for the first time, seen a minister of the government, the Honorable Baram Barugaha, has been listening to us from, I don't know if he's still on, but he has been listening to us for a very long time. I think he's very interested in what you're doing in the Tax Appeals Tribunal. What lessons can the judiciary learn? So first of all, by saying, I think judges in Uganda work extremely hard. Every time we come here, we look like we are pushing back at the courts, but I think it's fair to say that Ugandan judges are overburdened, overworked, overstretched. They sit, judges, I know of judges who used to give out 2 or 3 decisions in a day, at the same time hear matters. I know, for example, in Masaka, the bar recently put down its tools because of the overwhelming nature of work on the judicial officers, because the judicial officers couldn't strike, so the bar went on strike on behalf of the fact that they had one judge who was sitting there hearing cases. I know the Court of Appeal, for example, sits on 12,000 or 13,000 appeals. I know that the land division many times recently was taking up to 5 to 7 years to resolve a land dispute. Yet judges sit in that court every hour, and they sit and they finish and they write. And I know that at one time, I think we had the former, the retired Principal Judge Emeritus coming here, telling us that at one time he had a problem even writing. He had to go and get medical treatment because he had, I think, and I used to appear before him, and I think he probably must have, probably should check this out, he may have the world record in writing words, because just the number of cases he was hearing every day, and those days were using longhand. So first of all, when we say that the judiciary should take lessons, we must not be misunderstood for judiciary, what do they call them? They say bang the court. We must not be just misunderstood for banging. I think court bangers is the word I was thinking of, but it doesn't sound very appropriate. We mustn't be misunderstood in that respect. What we are talking about is what is already in the law. What can the judiciary learn, for example, from the Tax Appeals Tribunal? The use of specialization is something that is important. Specialized experts. Because I'm not going to bring a tax dispute to Stella, and I think she's not going to understand it, because she has really understood the Income Tax Act. So I think the use of specialized courts, I think the use of lawyers as mission-based judges is very clear. I think the employment of technology, although in some respects the judiciary has gone ahead of the Tax Appeals Tribunal, for example, with the introduction of ICMIS. But ultimately, I think the philosophy needs to change. I like the philosophy of saying, whether it's this side that wins or that side that wins, I have unlocked money into the economy. Not to say that I have saved government money, for example, or I have saved the private person's money, but to say the idea that let us unlock money into the philosophy of justice, to understand that the end goal of our courts is justice. We used to have a judicial system that was a bit more conservative. They'll tell you, I can't see you. You imagine, you have gone into court, someone has grabbed your property, you have called your lawyer, he is late, he comes rushing to court, and when he gets into court, your property is going. The judge says, I can't see you. How come you're not wearing the other white flaps? You know, there was I'll say this when we start talking, we may over talk, but there was this business of being responsive. You may end up in a situation like a policeman in Karamoja. You know, there was a policeman in Karamoja who, a Karamojong man came and told him that some guys from Kenya have come and have stolen my cows. We need to we need to move. And the policeman said, we first have to open a file. The man said, but I need you to help me chase the thieves. He said, no, we first have to open a file. The man said, okay, hurry up, open the file. What is needed in the file? He told him, what is your name? He gave him his name. He then asked him, what is your date of birth? The Karamajong man said, I'm going to slap you. People are taking my cows across the border, and for you want to know my date of birth. If it was yesterday or today, how is that saving my cow? And so we need to understand that Karamoja justice, that idea that don't ask me for my date of birth when the cows are crossing the border. And so I think TAT exemplifies that service. But also I think what is needed very much in the courts, and maybe not in TAT, but although it also affects TAT, I think what is needed in the courts is maybe the voice of the Law Society in the Judicial Service Commission, and maybe on top of the voice of the Law Society, people who are anyway. I think people who know. I think people who know. So maybe I should stop there. Stella, I'm sorry for answering questions like as if I'm the guest, but you will forgive. It's Alfred's fault. He's the one who asked.
Yeah, thank you for answering my question. As you're supposed to be asking questions. The normal question is for you. Maybe when you talked to the lawyer who was not seen, I have a lawyer who went and the judge was like, "Cancer, I can't see you," and he was like, "I came here to be heard, not to be seen." And the judge was like, "Okay, let me hear you." So maybe you can be radical as such, and you are heard. But yeah, we are coming down to the question. So if you have, I have one question in the comment section, in my inbox. So any other people who have questions, you can share them. You can request to speak. At the same, I know Joe is burning some question before you can have from the comment section or from the speakers or any person on call. Thank you.
Thank you, Alfred, and thank you everybody that has joined us today. It's been a while, and on the street they say it's been a minute since I last heard that if you know thing. And you know, Council Elson said he's a young lawyer, so probably, yeah. And I think also for the young lawyers on today, I'm receiving messages of, the numbers that are being talked about are very intimidating, because you're asking about 506 billion, and you're saying none of us in this room, okay, except Mrs. Stella, definitely. I think she has talked about the numbers, but you're saying none of us in this room has thought about it this week. But then there is a 200 million which has been referring to as, this small money. Small claims that people are saying 200 million is small money. And I think also, since we're talking about numbers, you'd earlier wanted to know how much Ministry of Health has on the budget, 2025-2026. It's around 4.4 trillion approximately. So we're talking numbers. Yes, okay. So let's continue being intimidated. Let's continue the intimidation. Mrs. Stella Nyapendi, we're really, really grateful for all the knowledge that you're sharing with us here today, and especially the fact that people are really adjusting, taking all these trust to another level and coming in and believing that actually they can get their disputes resolved. Now, when you look ahead, I know you've mentioned a little bit on some of the ways that you can expedite the process of covering maybe more disputes or handling more of them faster. But if we are to look in the future, I know you've mentioned a little bit about digitization. You've talked about the mission, I think you called them mission members? Missions. Yeah, not the mission-based judges, yeah. Yeah, you've also talked about the fact that you've inquired, you're in touch with other countries, for example, Kenya, where they're also using some of these things like digitization. So if you're to look ahead, what do you see as the future of TAT in terms of its role in supporting Uganda's economic growth? Thank you.
Thank you, Joy. Looking ahead, the tribunal is confident of its ability to provide a clear, provide a uniform, provide a rapid and just tax system, a just system for resolving tax disputes. And we know that once this is done, we directly will support Uganda's economic transformation. And so the future focus, apart from automation, I will again emphasize that we will target the nature of disputes, starting with the high-value disputes, while prioritizing them because we are cognizant of the fact that they hold 75% of the value of disputes that are before us. And when we unlock this, there's a significant amount that gets to the economy in the short to medium term. We believe that this targeted approach will directly support the tenfold strategy on maximizing returns from the public and indeed private investment. But also, like I'm speaking now, we will strategically reach out to the TAT users and broaden our reach and awareness, because if we promote the awareness of the tax appeals tribunal services, and then if we deepen our outreach in the upcountry regions, then where the presence has been largely unutilized, by the way, we have a small volume of cases in the regions, then we'll be able to support the skill-up approach of educating the population and foster national consensus. So we'll reach out to the public and the users, both taxpayers, and because everyone in this country is a taxpayer, we pay tax one way or the other. So you don't know at what point you might need that. You don't know at what point you will get an assessment from URA, because even looking at the nature of assessments, you'll have default assessments where you register for a business and you're not filing. Before you know it, there's an assessment, or you're being penalized. So we shall continue to reach out and ensure that people benefit from our services. And then we'll continue modernization, and then also put a lot of emphasis on ADR, because we've seen that it works. It works to the extent that when there's dialogue, between the parties, then it has the benefit of ensuring that tax disputes are concluded. Then there's also scaling and specialization. We are thinking of creating specialized panels. If it's transfer pricing, we have this panel, and it will listen to international tax disputes to look at transfer pricing. And then we'll also strengthen our regional registries. If we strengthen them, then it will help to reduce the concentration risk from a few high-value disputes. Then also, we cannot go without talking about legislative reforms. I mentioned earlier that we'll propose an amendment to the law to provide for single-member panels, and then also ensure that the issue of 30%, we've not debated it at length, but it continues to affect the filing of disputes before the Tax Appeals Tribunal, although we have been privileged to be guided by jurisprudence where an applicant can pay this 30% in installments where they're not able to pay within. So we have the discretion to allow for that. So for fitting cases, we're able to apply discretion, and then hear the taxpayer. So yes, we shall as well continue to provide and look at automation for increased efficiency. So we'll just have more of that emphasis. We've seen that ICMIS is working very well in the courts, and therefore we know that if we have a case management system and we have technology that is working, and a push for early ADR, even within the 7 days we're working with the Revenue Administration, we know that we shall be able to perform even more efficiently. Thank you.
I agree. Maybe just one word from me. I think it's really high time we did look at that 30%. For those who don't know, if you're going to have a dispute in the Tax Appeals Tribunal, you must pay 30% of the assessed amount. And I think that is closing a lot of people out and encouraging a lot of tax injustice. And I think maybe if we can have a punishment for losers other than a punishment for entrants, it can. If the fear is what is it called? The floodgates. If the fear is floodgates, then it has to have a punishment for losers, not a punishment for entrants, because a lot of tax injustice is happening under the guise of 30%. In fact, what you would call in business fraudulent accounting, because someone says we met our targets and his target is full of about 30%, and then he goes and loses it all. So, yeah, Alfred, over to you.
Yeah, thank you. I think this is the time where we get to get questions from our guests today. People have been following on Twitter, YouTube, and TikTok, and even had special guests who have joined us physically. We will have taxi a lot. There's a taxman, Trevor, and Senyo saying that he needs to join us physically, and Lidl, Kiruanga, and Lukwaga should have joined us physically to enjoy this conversation. So, from these people, one question which came from my hand, this one said, one of them, but I won't mention the name, but it's one of them who joined physically. It says, he realized that he left law school without anything related to practicing before the tax appeals tribunal. So it seems that it seems law school only train us to appear before ordinary courts. So, and now we're in the moments of rethinking legal education in Uganda. So, what education reforms can be implemented to address such challenges so that lawyers are trained to appear before, not only before ordinary courts, but even before such constitutional bodies, so that when they finish, and then they can't say, 3 years I'm not practicing because I don't have a PC, I don't know which, so that when they finish, they're not, let me say, close-minded of, it's not ordinary courts, I'm done. Whereas if they could appear in such courts. Thank you. That's the regarding education reforms we should consider.
Thank you, Alfred. For reforms that would embrace and guide lawyers to appear before TAT, I know that in LDC we had an opportunity to study taxation, and at that point there was quite a lot on the Tax Appeals Tribunal Act, and that made mention of the procedure and the appearances before the Tax Appeals Tribunal Act are governed by the appearance, by the procedure, by the way, in the high courts and the Court of Appeal and relevant courts. So the TAT appearances align themselves to the procedures in the CPR, the exception being that we can be informal and use our discretion. For example, if you're filing an application for extension of time, you can file using a notice of motion. These are documents that we were taught under legislative drafting, under commercial law, corporate. So these are documents that we were guided, and we went through these all procedures during the LDC sessions. But in terms of educational reforms, we shall just continue to emphasize that the facet, the aspect of TAT procedures is emphasized. I see that in the East African School of Taxation, but also just from the reading, and especially because this court is an informal court up here, ensure that you file the application, that you put your grounds, that you are able to support your case, that when you come before the Tax Appeals Tribunal, you will not be told that you cannot be seen because it's not expected that a lawyer comes robed. And when it comes to filing submission, for as long as you can cite authorities, so the reforms can come through the education process, through universities, even secondary education. That syllabus, by the way, is taught even at secondary level. And but for those who have completed their tertiary studies, LDC and the university, you can still follow through from the institutions that exist, East African School of Taxation, but more in terms of reading, but also to emphasize the fact that the TAT sessions are public sessions, so we invite you to make use and appear for the sessions and listen in and see how it goes, the way the arguments are raised, and how the procedure that we follow. So we are open. We are open. Oftentimes we have lawyers, young lawyers that come in and they listen in to the proceedings. That is acceptable. So that is also one way of learning. It need not be ingrained in the educational reform strategy. You can as well take benefit of that. So that is the advice I would give the lawyers who are interested in having practice before the Tax Appeals Tribunal. Thank you.
Thank you, Stella. That has been answered regarding the legal reforms and what can be done. Ashraf, I think you could ask your question from the physical audience who joined us today. Thank you.
Thank you so much, Council. I basically have questions for our guest today. The first question is all about, she talked about a proposal whereby the proposal goes by saying that with time they will propose that we could be having a single member panel that will be handling cases instead of a 3-member panel for cases of 200 million and below. So my question is, if at all this comes to pass, shall it only apply to the Kampala tribunal, or it will even be decentralized to other regional tax appeal tribunals? Then my last question is all about, I think it's usually every Sunday, if you follow the X-hand of Tax Appeals Tribunal, they usually provide for the cause list of the Kampala registry. So I'm someone who sometimes reside in Bali, whereby there's a regional office of the Tax Appeals Tribunal. So my question is, how do you, actually it's just a suggestion, whereby if you follow the cause list that they usually post is usually for the Kampala registry, how about if you see with time they even start involving other regions, because we know that X is not only for people of Kampala. We can have people of Bale, Mbarara, so in case they would wish to easily access the cause list of a particular week, how do you see if at all with time maybe you also think of people of those regions, whereby besides only posting the Kampala registry of a particular week, we can as well start posting for regional cause list of a particular week. So thank you so much. I basically had only those two concerns.
Thank you for that question. I'll start with the first question regarding the proposal to have small claims to be heard by a single member panel rather than a full panel of 3 members. This proposal I mentioned earlier that is bound to help dispose of such matters quickly, but also reduce the potential of backlog. Now, if that is passed into law and successfully, the scope will apply to all regions. It will not be limited to Kampala cases, because our presence is regional, and that means that where we have small claims, we shall apply the same principle across the board, because we are a tribunal whose scope extends to the country as a whole, but yet not limited to the central region. Now, about the cause list is circulated every Friday, not Sunday, and that is supposed to guide the users to prepare for the sessions as the week unfolds. So every Friday you will find the cause list circulated on our digital space, WhatsApp, LinkedIn, and on our website. And that cause list is not limited to the Kampala case. The Kampala cases. The cause list extends to the regional cases. If I take an example of the cases that are scheduled for let me see, this week, we have cases in Bale. On the 12th day of September, we'll have cases in Bale. We have a session, and we'll have panel members traveling to ensure that tax justice is available and accessible to our users in Bale. So you can check 12th September, we have at least 3 matters that are coming through in Bale, and so we have presence in the region. So the cause list is combined, but yet it separates. So you'll see from Friday we have Mbale cases, but we also have Kampala cases. And then where we have sessions in Barara, you'll see Barara cases, you'll have Kampala cases. And the same holds true for the other regions. If it's Gulu, we'll apply the same principle. So it works for the tribunal to have one cause list that speaks to the same cause of hearing cases on a specified date, and specifying the time as well. Thank you.
Stella, thank you very much. I thank you.
Oh, yes. Hello.
So
Hello.
thank you, Stella. I think we could have one more from Eric, and then we get to Mercy.
Oh. Yes, Ms. Stella, thank you. Yes, Ms. Stella, thank you so much for the insightful discussion. I know the conversation has been predominantly about tax dispute resolution and mainly breaking the backlog. I wanted to know if the tribunal has considered having a conversation about tax dispute avoidance, because ideally, if the taxpayers clearly understand their rights, their rights and their obligations, I believe they would not be quite disgruntled. So what efforts are being done by the tribunal to just a minute.
We've lost you. I think the question was already clear, and maybe you could just. I think we've lost you on. I don't know if I was the only one who lost him. I think we lost you, but I think the question. I think you got the question. What efforts are being done by the tribunal on avoidance?
Thank you for the question. Being that what efforts is the tribunal putting in place to ensure that disputes are not presented before it, I think that's a difficult one, because it's our business to resolve the disputes. Not that we want the disputes, but of course it's our business to resolve the disputes. But also, people have a right. People have a right to choose to come to the tribunal. However, maybe inadvertently, what the tribunal does is, if we have a case that was decided on a certain principle and it appears on the same, and it appears for adjudication before the tribunal, you'll get the same result. But also in terms of tax dispute avoidance, we, as much as we engage the users, we as well engage the URA during our stakeholder engagements, and where we know that there are mistakes that may come on their part as a result of their inactions or actions, then we advise them to comply to the extent possible. And the same goes to the taxpayers. They need to avoid disputes by filing returns, because as a taxpayer, you have obligations. You must file returns as dictated by law. You must file the returns within time to avoid penalties. You must also, the tax regime in this country is self-assessment. So you must declare the right taxes. If you declare the right taxes, then what it means is that you will not be caught on the wrong side of the taxman. We have a lot of cases that are in respect of under-declaration. So where you declare the right taxes, then you will not be expected to file. They will not find fault with you. Where you file your returns, your tax information on time, then you will not get the penalties. And where you file as expected, meet your tax obligations as a taxpayer, then you will not be found at the wrong side. But also, you keep your documents, your financials. Can you have audited accounts? If you have audited accounts, if you have accounts that speak to your expenditure, and then you're able to speak to that when a dispute arises, then you'll have that matter resolved with the tax administration. But also keeping the necessary documents, invoices, purchase-related documents. Then if you look at the bank statements, then also relevant documents, contractual, otherwise. We've seen cases where taxpayers contend that they got loans, but yet there's no document that speaks to the loan, there's no agreement, so it pays to keep the relevant documents for as long as you can, because you don't know at what point it might come to your rescue. Where there are resolutions of a company, can you ensure that we have the resolutions duly registered by URSB? All those really come to the rescue. So that is how to avoid disputes in tax, because it speaks to documents while emphasizing the fact that as the taxpayer, as an applicant, the onus is on you to prove that the decision made by the URA should have been made differently, or should have been made wrongly. Now, the other thing is that the onus again is on the taxpayer to prove that the taxation decision that gave rise to an assessment is excessive, and that you can only do by availing the relevant documents, your profit and loss accounts, all those documents that come through. So also we encourage taxpayers to employ the right, employ experts, employ accountants to do your accounting. If you're not able to file by yourself, those are available. They're tax agents. They're available to be able to support you to avoid you paying taxes that you ought not to have paid, because in the absence of the documents, URA almost has nothing to work with. They'll give you default assessments, they'll give you all manner of assessments, they'll penalize you because you have nothing that speaks to the assessment. Thank you.
My condolences is I've had news of the AGM happening on 7. Let me just confirm the date and be clear on the date. 17 September 2025. I hope part of what we are going to discuss is to have our commissioner into the office, and when we have got that date, all of us should remember to vote the lawyer's lawyer into the office, so that you can keep having these conversations, because now I've just had a masterclass of tax. I think I've got this question to start appearing there. It's fun to also be part of the people unlocking billions of money, even if I'm not touching it, but as long as I'm unlocking it, I can start from there. Thank you so much, Stella, for your time today.
Thank you. My closing remarks, it's been really an honor to have you, Stella. Thank you for honoring us with your time and answering our questions and teaching us all these kinds of things. But most importantly, for enabling us to have a conversation about numbers. Will probably take a year to talk about the billions and the trillions and all that. A push to the young lawyer, I think, to work hard, because... Oh, you can't hear me? Okay. Yeah, sorry about that. But yes, thank you very much, Stella, for honoring us with your precious time and teaching us and answering our questions, and most importantly for enabling us to discuss numbers that will probably take a long time before we get into such discussions. And I think a challenge to the young lawyer as well to work hard and find themselves in these spaces where these numbers are discussed, but also to interest themselves in tax and attend. I think she has mentioned that some of these sessions are very open. So for anyone who is interested out there, you can please go there and attend and see how it is done and get some knowledge. So thank you very much to the listeners and to the young lawyers that have decided to come and spend this evening with us in the room. We also want to appreciate you. Thank you.
Just one minute to add for protocol. I think after Shiba having the shout outs from Mercy, decided to pose a question and requested to speak, requested for just 2 minutes. Shiba, if you could unmute and just ask your question in 2 minutes before we close. 1 minute. Master said 1 minute. He just had to give you 1 minute. Thank you.
Thank you to the entire team for putting this so live. And kudos and gratitude to Stella and I think the other tribunal members. I saw Miss Nambi and Grace Afi on the space as well. So immense gratitude to you guys. But maybe Stella, I just want to pick your rich mind. We believe ADR is a problem in our tax practice, and there is a lot of conversations around what can be made better. So my question to you, Stella, is from where you sit, what are some of the changes you would like to see in our tax ADR space? There have been a lot of issues around the timelines and the like, but maybe just to pick your rich mind, what are some of those areas you would like to see changes proposed?
Thank you, Mr. Ichiba, for the question. ADR, alternative dispute resolution, is one of those areas that has been embraced by the URA and by the TAT to ensure that we expeditiously resolve and dispose of disputes. But the problem he's talking about, I know, is on the part of on the part that comes from the ADR regulations. These regulations were introduced under Section 24 of the Tax Procedures Code, and resulting from that, we had the ADR regulations that came into place in 2024, and the regulations provide for a taxpayer applying for ADR where they're in receipt of an objection decision. Now, when they receive the objection decision, they're expected to file for ADR within a period of 7 days. I had mentioned that for earlier. These 7 days have created a problem for the taxpayer because oftentimes there's ignorance to the extent that they're not aware of the law. And then at that point, I remain cognizant of the fact that ignorance of the law is no defense, but the reality is oftentimes applicants, taxpayers are not aware of the ADR option. So they will ignore it, come straight to TAT, and yet it's an issue that may have been resolved in ADR. They'll come to TAT and they don't have the 30% to pay. Now, ADR being a problem comes from the fact that usually when the URA begins to resolve disputes through ADR, sometimes they conduct fresh audits, and that is time consuming. Sometimes they will demand that the taxpayer pays the 30% of the tax in dispute, and yet ADR is supposed to be a meeting of minds, and then you have a conversation and you present supporting documents. So in terms of what can be made better, I'll start with the timelines. 7 days to file an application for ADR, and the fact that the same can run concurrently before the same can run concurrently with the TAT application, there should be an amendment to the timelines. The 7 days is too short. There is need to expand that time period, but yet in expanding the time period, the regulations do not as well provide for a period within which URA should respond to the taxpayer after the taxpayer having filed for ADR within the 7-day period. So because that is lacking, then you see that that regulation disadvantages the taxpayer because it doesn't provide for timelines for URA to reach a decision. Maybe that then impacts on their delivery timelines in terms of giving a response to the taxpayer. So there should be legislative reforms to the ADR process internally. Then also many of the cases before TAT will suffer some delay because the administrative channels which URA has to follow, and this is a committee called the Oversight Committee. Oftentimes when the taxpayers appear before TAT or the respondent URA will tell us that this matter is before the ADR Oversight Committee. We've taken it to the committee for consideration. We cannot have that consent until the committee has taken a decision. So there has to be some reforms around the ADR Oversight Committee, the timelines, the time it takes to approve cases, and then also the ADR regulations have exceptions. They will not look at disputes that are regarding fraud, invoice trading, legal interpretation. So there are a lot of exceptions in the ADR regulations. So I would propose for some reforms around the legislation to improve on ADR, because by intention it is a well thought out process, but there should be value to the taxpayer, there should be value to those who are aggrieved. And then coming to TAT, there should be certainty as to whether an ADR decision is a tax decision. We have decisions that say an ADR decision is not a tax decision because after the commissioner in domestic taxes making a taxation decision, then the other commissioner in legal services making an ADR decision, there's a school of thought that is to the effect that then the respondent is factors official. But yet, there's a school of thought that reasons that an ADR decision coming from URA is a taxation decision, and therefore a taxpayer should be given audience when they come before the TAT. So those are reforms that should be thought about, and I know they can be very useful to our tax dispute resolution process, and ultimately to the TAT and to the taxpayer and to the respondent as well, URA. I'll go straight to the parting shots.
Just for going to parting shots, we just have one last question. The last one, as Edison keeps saying, from to Haire. Just in 1 minute, keep 1 minute and pose your questions, because we're running short out of time, but we don't want to leave you behind.
I do not have a question, just to give a vote of thanks to her for a very well delivered presentation. And thank you to the organizers.
Thank you for the commentaries and parting shots. I would not conclude this conversation without making mention of the reason for our very existence, this being the taxpayers and the Uganda Revenue Authority, who are the one respondent in all our matters. You know, in other jurisdictions, revenue authorities can as well file applications, but in Uganda's case, we have URA on the other side. But I'll go ahead and really appreciate them. They are definitely the reason for our existence. Where we have a matter and you have one party missing, we are not able to proceed. It really will affect our timelines, it will affect our delivery, and so we cannot end this without appreciating them. Then we also extend our appreciation to the parties for their cooperation, because if they don't cooperate, then again, as much as we push them and we pull and push, we are not able to reach consensus. So we thank them for their cooperation, more especially for embracing the changes that we introduced over the years. I mean, especially last year, we had a number of reforms, and whereas the reforms are working to ensure disposal, but I know that sometimes you have the lawyers crisscrossing the two courtrooms and having many, because you have sessions running after the other. So we thank them for their cooperation. On the part of the Tax Appeals Tribunal, we remain committed to serving the public honorably. We remain committed to dutifully providing a clear, uniform and rapid tax dispute resolution system. we know that if we do our part as our mandate dictates within the law, then the system of resolving the tax disputes will only but be just, and it will be deemed fair, it will be deemed independent, and that can only come from the outcome that they get from us. So our purpose remains to build trust in Uganda's tax system, and by doing so, we know that we will ultimately continue to be a critical enabler of Uganda's transformation journey. I thank you.
Thank you very much, Stella, and thank you for everybody who has joined us from wherever you've joined us from. I think it's been a fascinating conversation. I've seen a comment which I will read from someone called Calvin, that when you hear Mrs. Stella Nyapendi Chombo speak about tax and tat, you immediately develop this urge to drop whatever you're doing and go and study law. I don't understand why he hasn't studied it yet, but it is good that he has now developed this urge to drop everything that he's doing. And I thank you, Stella, really for inspiring people. I really want to agree with Amutere and really thank you, extremely thank you so much for the time. I think we've been here now for more than 2.5 hours. Please greet our learned friend, Mr. Chombo, as well, and thank him for releasing you to for these 2.5 hours to really speak with Uganda about tax justice and about justice, about backlog, about growth. While we were here, I've seen a tweet which Alfred has brought to my attention from the Uganda Law Society that reads as follows. Accordingly, the Governing Council hereby notifies all members that a general meeting will be held on the 17th of September 2025 at Imperial Royal Hotel, Kampala, commencing at 2:30 p.m. Close quote. They are quoting Mr. Anthony Asimwe, the Vice President of the Uganda Law Society. Colleagues will agree that, Stella, we've been having these conversations since January, and we've walked a very long road on these judicial service conversations and on this Judicial Service Commission election. We were supposed to have an election, for those who don't know, in December of 2024, on the 17th of December 2024. So this is what you call backlog. This is one of the effects of backlog. And sometimes it is true to say that for members of the society, and definitely for candidates, myself included, this burden seemed very heavy. Some of our colleagues even ran out of fuel. But now, I think the Law Society has given us direction of having a meeting. And it is my submission that the affairs of the society should go back to where they belong, to the hands of its members. And it is time for the members of the society to summon the will and to decide that this reggae must play. And to decide that we must determine the affairs of our society, not through the well-written briefs of council or the wise rulings of their lordships, but through the democratic contestations being expressed in the society. Now that that time is actually fast approaching, members of the Law Society know, and I'm sure understand, the important challenges that are ahead of us. They know those who run sprints and those who run marathons. They know what is really ahead of us. And I want to encourage members to attend that meeting, to contribute at that meeting, and to agree at that meeting that without fail and before long, the Uganda Law Society representatives to the Judicial Service Commission must be elected. And when you do go to vote, as you're thinking of that election, as you're stuck in a voting basin, looking at these almost 9 months that have passed, remembering the wise words we've had on these spaces, including today, understanding the challenges affecting our society, I will be beseeching members of the Uganda Law Society to consider my candidature very seriously. And when you're considering it, I want to propose a song that you can consider it with, because I think since from January up to now, we have traveled this entire country, visited literally every court, talked to hundreds of lawyers, and engaged on the issue, and brought the best CLE, pointless CLE nonetheless, but the best CLE to the membership of the society. And I think it is time that members facing a voting basin will agree with me in the words of the legendary Mr. Matovu. Oli mujawa musajja asinga nze.